Judgment in the appeal, Societe Generale against Geys.
The judgment will be given by Lord Wilson.
Mr. Geys is a Belgian citizen. In February 2005, Societe Generale employed him to work in its London branch as managing director of a department of its Financial Institutions Division. On 29 November 2007, the bank informed Mr. Geys that his employment was terminated with immediate effect. It escorted him from the building, and he never returned to it. It is agreed that the contract did not permit the bank to sack Mr. Geys in that way. Indeed, it was a wrongful repudiation of the contract. In these proceedings, Mr. Geys makes claims, which the bank disputes, about the size of the payment to which he is now entitled under the terms of that contract. On any view, the terms entitle him to a substantial termination payment. But how should it be calculated? And do the terms under which he is to receive the payment preclude his making other claims, namely for damages for alleged breach of, for example, the clause in the contract which required the bank to use all reasonable endeavours to ensure that bonuses were paid to him in a tax-efficient manner? Mr. Geys, in effect, won on all the above issues before the trial judge, lost on all of them before the Court of Appeal, and now appeals to this court. The court allows his appeal. The court holds unanimously on this issue that the terms which oblige the bank to make the termination payment to Mr. Geys, and which oblige him to accept it, do not prevent him from making his proposed claim for damages. This conclusion has no wider legal significance. Much more widely significant is the resolution of the dispute about the calculation of Mr. Geys' termination payment. Under the contract, part of his termination payment is to be calculated by reference to the date when his employment was terminated. If it was terminated in 2007, it is to be calculated by reference to results in 2005 and 2006. But if it was terminated in 2008, it is to be calculated by reference to results in 2006 and 2007. Results in 2007 were better than in 2005. So the battleground has been whether, as the bank says, Mr. Geys' contract was terminated in 2007, or whether, as he says, it was terminated in 2008. In this respect, the bank puts forward two alternative arguments, namely that the contract was terminated either on 18 December 2007 or on 29 November 2007 itself. By a majority, Lord Sumption dissenting on both points, the court rejects both of the bank's arguments and holds that the contract was terminated only in 2008. The bank's 18 December argument is based on the payment in lieu of notice clause, the pylon clause in the contract. This clause entitled the bank to terminate the employment of Mr. Geys at any time by making a payment to him in lieu of notice calculated in accordance with criteria there specified. On 18 December, the bank transferred into Mr. Geys' bank account a payment calculated correctly under the clause. But it was not until 2008 that it told Mr. Geys that it had invoked the pylon clause and that the payment was referable to it. The majority holds that the operation of the clause was invalid until the bank told Mr. Geys that it was exercising its right of termination thereunder and had made or was making the appropriate payment to him. The bank's 29 November argument raises for employment lawyers a major issue of law which has been simmering for 60 years. It is whether a wrongful repudiation of a contract of employment, such as occurred on that day, is subject to the usual principle that it terminates the contract only if and when accepted by the innocent party, or whether it terminates the contract at once because of the special features of such a contract. In particular, the court's well-established refusal to order an employer who has wrongfully sacked an employee to take him back. Today's judgments take this simmering issue off the hob, and to continue the metaphor, the issue will now be set for England and Wales, in the way in which it already is for other common law jurisdictions. Notwithstanding a powerful dissent by Lord Sumption, the other members of the court unequivocally held that the special features of a contract of employment do not serve to disapply the usual principle that a wrongful repudiation terminates a contract only if and when it is accepted. Since Mr. Geys did not accept it until 2008, he is entitled to the higher payment calculated in part by reference to results in 2007.
The court is now adjourned. During pleasure.